on bail, no?
My lord?
You're on bail
Yes, I am on bail.
after Bihu, after Puja, after May, winter vacation. After winter vacation, you are on bail because now I'll have to fix bail
Yes,
matters.
is at Majuli, my lord. So he's on old man, man.
I'll have to fix bail matters next week. First day, 6th January. Huh?
No, then
5th
let
January.
me try through registry if possible.
Worship, I pray for listing this criminal petition. It was earlier listed on 15/11/2023. I am for the petition.
Criminal petition.
Yes. After vacation, my lord.
After vacation.
First week of January.
Yes.
Date may be given, my lord. Huh?
May I please your lordship, my lord, criminal I have filed, my lord, regarding parole, my lord, it may criminal appeal admitted, LCR called for receipt and pending, my lord. Mother expired on last 22/11, my lord. So some mandatory.
He's in jail.
Yes, right, yes, my lord. So some parole petition filed on next week, any day, your lordship, my lord.
Okay.
Obliged.
May I please not? I beg to mention for listing criminal petition. Not to kindly list the matter of 7th January.
I have, may I please? I have filed a criminal issue, my lord, but serial number 11748, my lord. There is an urgency, my lord. May I pray for list on 15th Monday,
Criminal petition.
criminal petition, my lord.
What kind of urgency?
Matter relating to domestic violence, my lord. We have prayed for passing and as well as stay, my lord. There is some urgency, my lord. All parents has been arrayed as party, my lord. Obliged.
May I please your lordship? I want to mention for withdrawal of criminal revision petition number 132.
May I please? Lordship, yesterday I filed an additional affidavit in item number 9. That may be called for, my lord. I'm obliged.
May it please your lordship, I beg to mention item number 35 of daily list. Lordship, kindly pass over the matter for the day.
A request has been made to pass over the matter for a day, which is allowed. Item number?
35. Obliged.
For listing of an EV on Monday, madam, it was filed on 8th, but even on 15th, it has not been listed, madam. For Monday, madam.
Tuesday.
Tuesday, read to it.
This
35
criminal,
को सुने ना?
this criminal appeal is registered on October, my lord. But till date it is not listed, my lord. The appellant is behind the bar since 2024, my lord. Wednesday, my lord. I'll pray for bail, my lord. Hello, blood.
I beg to mention for listing IA, my lord, for 1246 of 2025. It was filed on 16th November. So kindly, you want to.
I for what?
IA criminal
For?
for vacating the stay order.
No, after vacations. Vacating stay order after vacation. 9 January.
May it please your lordship. Beg to mention for listing of a bail application on Monday, lordship.
Bail application.
BA, lordship.
On Monday, yes.
Obliged, lordship.
May it please your lordship.
So item 26, I have been told by my learned friend that CD is not received. lordship.
CDS corporate not receive issue reminder, list the matter on your interim bail.
No.
Huh?
Lordship may kindly fix the matter after vacation. lordship.
Vacation, madam.
20,
Lordship.
item number?
26
Okay.
on 7 January.
May it please your honor, I want to pray for listing a case, criminal petition 1269. It was never, matlab,
20.
it was case we are challenging proceeding. This was the actually listed on back 2310, but after that it was never listed. This case.
Criminal petition after vacation.
1269, 2025.
9 January.
May it please your lordship, I beg to mention item number 20 of today's list. I've inquired with my learned friend. CD
CDS corporate not receive issue reminder, list the matter on
there is an interim.
interim order shall remain for till then.
Obliged.
Item 1.
Due to some personal difficulty, Mr. P. Bora, senior advocate, will not be able to appear today. I love may kindly take it on after vacation, lordship.
Learned counsel Miss
K. Sharma.
K. Sharma on behalf of Learned Senior Counsel Mr. P. Bora has prayed for adjournment, list the matter after vacation. Very some matter date দিব কৈছে দেই ৰেজিষ্ট্ৰি মানা কৰিলেও নহব সব মেটাৰ ডেট দিব কৈছে আৰু জাজমেন্টও ওলাইছে সব মেটাৰ ডেট দিব কৈছে
বসো, বসো, বসো।
May I please, Your Lordship, this is a criminal revision petition, vehicle for, Lima for vehicle, my lord. Interim order is page 23, my lord.
You will call for a report?
My lord.
Sassoon has been submitted?
No, Lord. The investigation.
We will call for a report. We do not want a CD, we call
My
for a
lord.
report. Call for a report from the IO relating to the vehicle seized in connection with this case. This is the matter January, 5th January.
God bless.
Item number 3 and 4.
May I please, Your Honor? In connection to both the items 2 and 3, the petitioner, 3 and 4, the petitioner and the respondents were husband and wife. And thereby, all these altercations happened. And finally, they had entered into a MOU, Your Lordship.
Memorandum.
And they have agreed to withdraw the matters, Your Lordship.
That-
Lordship, may I kindly see the MOU?
That is a
at
page
the-
number 7. The item regarding the item number, item
Three.
number 3.
Three.
I would like to draw your attention towards the page number.
Page number,
The page number 39, Lordship. The.
1433.
Take me.
1433.
Yes, Lordship, the first one.
Okay, page 39, yes.
The London trial court has taken cognizance against the petitioner number 1 and 3. Actually, facts of the case is that, Lordship, both the parties got married on 20th April 2003. Thereafter, the social marriage was performed on 7/5/2003. Due to some matrimonial dispute, the petitioner filed one FIR before the Sadgaon police station. That was subsequently become a PRC case number 244/2000. They have came before this honorable court for quashing of this proceeding, and this honorable court also granted a stay of the further proceedings. We also actually, we have signed one during the proceedings of our family court case as in mutual divorce. One memorandum of understanding was entered into between both the parties. So as per this memorandum of understanding, both the parties shall withdraw each other's case. Lordship, page number 29, that is memorandum of understanding.
So
Actually-
have you started withdrawing the cases?
all are
Yes, sir.
withdrawn. Divorce has also been granted, Lordship. And the only pending
Only
cases are
this-
these two matters,
these
item
two
number
matters
3 and 4.
Pending
Page
only.
20.
Lordship,
Page 2, ma'am.
29,
29, Lordship.
page 29,
29 of item number 3, Lordship.
29 of item number 3.
And in this,
The relevant portion is at
At
page
page
30.
30, Lordship.
30. That is withdrawal. Both the husband and wife shall withdraw, cooperate in quashing all their cases, file in courts or anywhere else against each other and their family members enumerated herewith. That is as if that one converted into a mutual divorce, and then already divorce has been granted, Lordship. By order to the 3/5/2025, Lordship. Therefore, the DB
filed a-
case also withdrawn, no? DB cases
everything.
are done, both the DB cases, except two cases are there. That is PRC case number 244.
This petition, Indrani Burman and Yogzuri.
Yes, I have.
she is the wife.
This,
I'm
you
the
are the
wife.
jointly filed petition.
Lordship.
This is jointly filed?
No,
Yes.
no, Lordship. Item
no,
number
no.
3, item
This
number 3 has
thing-
been filed by the wife, the petitioner.
No, no. Indrani Burman and Yogzuri Burman together, they have filed this petition.
This memorandum of understanding.
MOU, Lordship.
MOU, both the.
Agreed upon during the trial of in the family court, Lordship.
No, no. The memorandum of understanding has been filed, petition also is jointly filed. Item number 3.
Yes.
No,
no,
Lordship,
no.
actually, this case, they have.
We have given
fi-
our affidavit in
That
affidavit
they
in
have
opposition,
objection.
giving the no objection, Lordship. But we have not
You
filed
see,
together.
Just check. Page number 2 of the petition, you have jointly filed.
The item number 3, Lordship, may kindly check.
Yes,
I-
item number 3.
3, and the item number 4,
1433.
that is present, Lordship.
They have jointly filed.
No.
No,
Actually,
Hirajiti
case,
Burman is the no, no,
is a brother.
brother of the
Indrani Burman.
Okay, Hirajiti Burman is brother.
Brother of
brother.
the Indrani Burman,
Himanish is the
husband.
husband, Lordship.
So we have come before this
Mani
court for,
Bora is husband.
yes,
Item 4, Lordship.
we have come before this court, before this honorable court for quashing of this case filed by the husband.
Here you are state respondent number 1.
My lord,
item number
in the
2.
item number 3, my lord,
Hmm.
it was the Indian Burman wife.
Hmm.
And the response number 2 is the
Manish.
Himanish Bora, he is the husband, my lord.
Among Bara.
For the
Correct.
cases, you are state respondent number 1.
My lord, state is just number one.
এইটো দুটা কেছ একেলগে লিখি দিছা হা
Second, you can proceed.
এইটো criminal
Worship,
section 1
the,
4
Case, cases speaks on 26/12. Until watching.
I'm passing the order.
Okay.
The criminal petition 1433/2025 with particular নাম চামবোৰ লিখি দিবা হা with criminal
1.5 months later, he approached the police station, and in the meantime, we secured the interim injunction application order from the district court. That's so.
let's see the order.
Yes, Your Lordship. The additional affidavit that we filed at annex A, page 50.
Read it.
23, dated 23/5/25. I'll come to the operative portion on the last page. So, in the opinion of the court, the petitioner has established a strong prima facie case at this stage, and the balance of convenience is also tilting in his favor.
No, how can I know the whole story?
Yeah, Your Lordship. Then I'll come through the orders itself. So, page number 51. I have perused the injunction application pleading in the main suit and the documents relied on. The main suit is filed by the plaintiff for declaration and damages to the tune of 3 crores for the harm caused to the petitioner's reputation, his future political prospects, damages from monetary loss of his business for the statements made by the defendants, permanent injunction, and other reliefs. The petitioner plaintiff stated that he has a reputable political career which started with the NSUI. He was the NSUI vice president in 94, and from 96 to 2002, he was the youth president of Youth Congress. In 2002, he became the general secretary of Karimganj Congress Committee. From 2011 to 2017, he was the vice president of Karimganj Congress Committee. And from 2017 to 2021, he was the secretary of Assam Pradesh Congress Committee.
All right, please take.
Yes.
Our learned counsel, Mr.
A. Sahu, Your Lordship.
A. Sahu,
A. Sahu, Your Lordship.
on behalf of.
For the petitioner, Your Lordship.
No,
But it's on record, my colleague is on record. I'm an outstation. I'm an outstation counsel.
His name is there in the Vakalatnama, but since he is outstation, it is not reflected in the.
Vakalatnama.
Yes, my name is there, Your Lordship.
Where you come from?
Manipur, Your Lordship.
Our learned counsel, Mr. A. Sahu, for the petitioner. Amir Rashid Chaudhary, who has filed his application under section 528 of the BNW 2023, read with article 227 of the Constitution of India, with prayer to quash the proceedings of Yasi case number 1841 of 2025, DI case number 750 of 2025, pending in the court of the learned Chief Judicial Magistrate Sri Bhumi, arising within bracket लिख दिया, arising out of Karimganj PS case number 248 of 2025. The allegation brought up against the petitioner is that he demanded money in lieu, LIE, of a ticket for Panchayat elections. Panchayat elections.
Panchayat elections.
For Panchayat elections. First off, it is submitted that the FIR, that the Panchayat elections were held on. When the election held?
May, Your Lordship. May.
In the month of May, 2020, in the month of May 2025.
25.
It is further submitted that the FI clearly reflects that it was lost after how many months?
1.5 months.
Huh?
More than 1.5 months.
More, was lost after more than 1.5 months of the alleged incident, full stop. It is further submitted that when a claim for damages was made and when the petitioner had obtained an injunction order, this FIR was lodged. Full stop. The petitioner has submitted the injunction or has annexed the injunction order as annexure A of the additional affidavit,
Yes, your lordship.
which was passed on
23/5.
2025, whereas the FIR was lodged on. FIR was lodged earlier.
Earlier, 21.
21/5. This case was instituted earlier to that, my lord.
No, my lord, that is injunction order received later on, my lord. FIR filed on 21/5, my lord.
Not properly substantiated
My lord.
to submissions.
Your
We'll call
lordship,
for the records.
your
My lord.
lordship, the primary submission, your lordship, is that
Nothing of conference.
this was a civil dispute, your lordship. Even if accepted on face value, your lordship, this is a civil dispute.
It injunction or to categorizations, injunction order subject. Let the records come.
My
We'll give you we'll pass an order
My lord.
Lordship,
after the records come.
very, very much.
Trial court records is called for is not received, issue reminder, backing thabo.
No.
Khali he injunction order se bagi nalas. List the matter after vacation.
Yes.
7, my lord.
Item 6.
May preserve. Madam, in this case, madam, we are challenging the impugn order dated 10/10/25 passed by executive magistrate, whereby the present petitioner was made to pay fine of rupees 50,000 and also furnish a bond of rupees 1 lakh. Now, my lord, the case is that is a non-FIR case. Proceeding took place under section the provision of 126 of the BNSS, formerly 107. Now, my lord, as per this provision, my lord, as section 135(6), my lord, the inquiry under this section, my lord, ought to be completed within a period of 6 months from the date of initiation. But from the record shows that this order was passed after 6 months and no special reason was also afforded for continuing the proceeding. And moreover, my lord, if
Okay,
we
we get the records.
Yes,
We'll
ma'am.
come to know why it was passed after 6 months.
Till
Notice
then,
to
only
be-
the thing is that, my lord, he was made to pay, directed to penalty of rupees 50,000. That may be stayed, my lord. Because, my lord, on the very first day, when we went, my lord, thereafter, before the completion of this proceeding, I was made to sign a bond, my lord. That is your lordship will find an annexure 2. On 9/6, I was meant to sign a bond. Now, in the order, there is no reflection that after 9/6, I have made any breach of peace, my lord. There is nothing in the record, my lord. After 9/6/25, I have committed any breach
If
of
you
peace.
give the record, then we'll get whether we'll get to know whether there is anything.
Yes,
in the
lordship.
record.
Order
In
in
and
the-
in findings,
Records is very
lordship, page
important.
16.
Yeah, it is necessary.
In findings, lordship, page 16, lordship, it is stated that,
16?
yes, lordship.
Hmm.
Despite executing a peace bond on 9/6/25, Srimati Hazarika repeatedly violate its terms. These violations were corroborated by video evidence, which is now part of the official record,
Ah.
lordship.
This thing, my lord, I want to point out.
Let us call for the record.
Lordship.
Issue notice. Learned Counsel, Mr.
I showed him.
I. Sohuriana.
I showed it.
I. Sohri is present for the petitioner. Learned additional PP is present for the respondent state and has accepted notice on behalf of the respondent, and thus no formal notice is required to be issued. However, sufficient copies to be furnished. To stop, issue notice to the respondent number 2, returnable on date given. Meanwhile, call for this is final order, so when we can call for the order record.
Only
for
thing
the
is,
records,
the
no?
the amount of 50,000 that is directed to be paid, that may be stated.
We'll call for the records, then they won't be executed also. Item 7. Call for the records.
May it please your lordship.
Yes, please.
My lord, the present petition under section 520 for quashing of a charge sheet, my lord. In this, my lord, before taking to the merit of the case, my lord, I'd like to say, my lord, FIR lost on, my lord, on 24 July 2014, my lord. After prolonged delay of, my lord, I'll come, my lord.
302, come.
No, no, I'll come, my lord. I'll come, my lord. My lord,
Stay,
I'll-
no, no.
no, I'll come, my lord. I'll, lordship, kindly, and 2 minutes I may be allowed, my lord. After whatever lordship will, my
You
lord.
can take the whole day, 302 I have not
My
stayed.
lord, I will come, my lord.
After 10 years, my lord, after 10 years, my lord, we are not an FIR name accused person, my lord. The person whom against whom allegation, he is not there in the charge sheet. Even after 10 years of, my lord, more than 10 years, my lord, charge sheet has been filed surprisingly, my lord. And most surprisingly, this honorable court and also apex court, even, my lord, after prolonged delay in filing of the charge sheet, after 8 years, may interfere. Even this honorable court interfered, same on the same situation, my lord. For 10 years, my lord, this honorable was the proceeding, and honorable apex court was the proceeding after 8 years, my lord. Yes, my lord. So,
Record command, record.
a record, of course, necessary, my lord. Of course, necessary, my lord. So, my lord, that appearance for us, our appearance is gone after 10 years, my lord, suddenly and surprisingly, my lord, one FIR charge sheet has been filed against them, my lord. Some protection may be provided to us, my lord. Let them call the record, my lord. Then my humble submission, my lord, can let it be fixed in the amount of time. No, I first time, my lord, my lord. So, my
You
lord,
want protection through this.
for appearance, my lord, before the SDGM, my lord, SDGM, the charge sheet,
But you
place.
have to apply for anticipatory bail. If you want protection, you will have to apply for anticipatory bail.
Well,
not
the charge sheet has been filed already, my lord. We are for quashing here before this court, my lord.
We
But
will
appearance
quash it.
fixed, my lord.
But if you want protection, you
Then, my lord,
apply-
but my humbly submitting. Lordship may call for the records, my lord, call for the records for SDGM, my lord, and fix the January, my lord. I will place for the interim on receivable or LCR, my lord. That much, my lord.
Learned counsel Mr. P.K. Dedanu is present for the petitioner. Who has filed this application under section 528 of the BNWS credit with prayer for quashing the entire proceeding arising out of Silchar PS case number 1853/2014 under section 302 IPC stating that charge sheet was submitted after
More than 10 years.
after an inexplicable delay of 10 years of investigation, full stop. Call for the scanned copies of the trial court records. Lana additional PP Mr. B. Soma is present for a respondent number 1 and has accepted notice. And thus no further notice is required to be issued. Extra copies to be furnished. Issue notice to the respondent number.
Two,
Returnable on date of the
January, my lord.
on 20 January.
Yes,
20
my lord.
January.
And in my, if open, kindly, my lord.
The prayer for interim protection may be considered on receipt of the record.
Deeply obliged.
Scanned copies of the trial court record.
Deeply obliged. Deeply
You
obliged.
know, very call for scanned copies of trial court records along with scanned copies of CD.
Lana, the SDGM, my lord, Kasar Silchar, my lord, can it be recorded? It's
No,
been.
no,
Yes.
they,
Obliged.
Send a message to the purpose.
Yes, deeply obliged.
I can wait.
Wait, Your Lordship.
Mm.
Lordship, this is a quashing petition jointly by the informant and the accused, Lordship.
Mm.
Accused is 17 years old, so he is represented by his mother, Lordship. The FIR is at page, Lordship, 9, annexure 1. Relevant portion I am reading from page 11, Lordship. Only the theft of a scooter, Lordship. With you, page 11, Lordship.
Means.
With due respect, I beg to inform you that my Activa 3G vehicle was stolen by one Mansoor Ali while he came with me to my workplace at Islampur Orchid Apartment. When I went to my employer's flat, that is Concord Apartment, to bring the car keys, the said accused person left with my Activa 3G from the parking of Orchid Apartment. I know the accused person as a laborer who is residing near GMC at TV Tower. Immediately, I went to his house, but he was not there, only his mother present in the house, who informed me that last Thursday her son was released from jail. Therefore, I would remain ever grateful if Your Honor investigate the matter and recover my vehicle. Interestingly, what happened, Lordship, in this case, when he approached the mother of the accused, Lordship, later,
He's 19 years old, no?
Lordship, I have filed FIR saying that he is 19 years old, but when they approached me, Lordship, it reflected that he is 17 years old only. So,
When?
Lordship, they came to my house and they handed over the vehicle. So vehicle was recovered. And thereafter, police is harassing, Lordship. After 1 month, they again asked me to produce the vehicle, and accordingly, we have produced the vehicle as per notice. That is, Lordship, can we see annexure 2, page 30?
You are a complainant?
Yes, I am the informant. A notice was served to the informant, page 13, annexure 2, to produce the vehicle on or before 26/11/2025. Accordingly, the informant Lordship produced the vehicle and they have seized the vehicle. Now I have filed one seize application, Lordship, for Jimma petition. Report is not submitted by the police till now in the Jimma court, Lordship. So I am praying to quash this petition jointly by the informant and the accused, Lordship. Seizure list, Lordship, I have enclosed as annexure 4, page 18.
Yes.
My lord,
The joint petition.
my lord, where it is also, my lord, if it is duly filed by the, but from the FIR, my lord, page 11, my lord,
Mm.
it looks like he is a habitual offender, my lord. He is just released from the jail, my lord, thereby he take again vehicle, my lord.
He's a juvenile, Lordship. I have no grievance against him, Lordship. And 379, it's a compoundable, Lordship, as per 320, Lordship.
I think up to certain amount, not a scooter.
Scooter, Lordship, this is my vehicle and I have recovered the vehicle. I have informed police about recovery of the vehicle and then I informed that I do not want to proceed with the case, Lordship. Only had a abuse of the process of
Charge sheet has
the.
been submitted.
No, Lordship.
No.
We'll call for a case diary.
Notice and call for that.
Lordship, it's a call by the PS. Can it be taken up at 2 p.m. Lordship?
No, no, not possible. How will it will have to send
Then on
for
Monday, Lordship. If possible. The Jimma court, Lordship, they are not furnishing the report to the Jimma court also. Only the police is harassing the petitioner, number one, only because he has not handed over the vehicle within 1 month, Lordship. I have recovered the vehicle. I have informed the police that I do not want to pursue the case. Even then, Lordship, notice was served. So this is a joint petition. I think, Your Lordship, I have a decision of Supreme Court which says even if it is not reflected in the 320 schedule, Lordship, that can also be compromised, Lordship.
We can compromise.
Yes, Lordship. And 490 and all these sections can be compromised.
Yes.
This is only 379.
Lordship may fix it
I
next
hope
week,
my
in the last.
learned friend will not object to this, Your Lordship. The vehicle has been seized, Lordship. And joint petition, Lordship, he may be punished in other cases. I have no objection, Lordship.
What
Only
is
for
the judgment?
Lordship, this is B.S. Joshi.
Which paragraph?
Lordship, the last paragraph, it says, even if it is not mentioned in the 320 schedule, those Lordship can be. Last paragraph, Your Lordship, may say that 482, there is no bar in the power of the High Court.
This is family.
Yes, Lordship,
Family.
498 matter.
There are many
And
judgments.
379,
Family
Lordship.
dispute can be settled. There are
Yes,
many.
Lordship. And 379, Lordship, that is tolling of a vehicle only. It's a scooty, Lordship. For that only the joint petition was when I have no grievance and Lordship, the vehicle also recovered. So there remains nothing. Only this is a abuse of the process of the court, Lordship. Later,
Have you mentioned that he is being harassed by the police?
Lordship, that I
The
have mentioned
petitioner?
that in spite of all this, they have served notice to the petitioner.
Which paragraph you have quoted?
Page 3, paragraph 3, Lordship.
And in this judgment?
Judgment last page, Lordship.
Last page, okay. All right, then. They don't want to proceed. He's 17 years old.
Earlier he arrested in the jail. Thereafter, when he returned, again he committed theft.
They may
The
arrest him
vehicle.
in any other case, Lordship. I have no objection, Lordship, but in respect to this case, Lordship, I do not want to proceed with the Lordship FIR. Judgment in paragraph
Learned Counsel
15.
Ms. R. Chaudhary for the the petitioners, who had jointly filed this petition under section 528 of the BNW 2023 with prayer to quash the entire proceeding of GR case number 4988 of 2025 arising out of Cordon Plaza PS case number 308 of 2025. Post of the petitioner is the complainant himself And the petitioner number one, the petitioner number one is accompanied himself, and the petitioner number two is the accused, who is 17 years old, who is who is allegedly the accused, who is allegedly the accused, is only 17 years old and is represented by his mother, comma, he being a minor, is stop. The learned heard Mr. B. Sharma, learned additional PP for the respondent state, full stop. The learned additional PP has accepted notice, and thus no further notice is required to be issued, full stop. Serious objections have been raised by the learned additional PP stating that despite the despite the compromise between both the parties, the proceeding is not required to be quashed, as the petitioner number two appears to be a habitual offender. So it is submitted that the petitioner number two was in jail, and after he was released from jail, he committed the offense for the second time. He repeated the offense. He repeated the offense of theft, committed the offense of theft for the second time. He repeated the offense of theft, full stop. The allegation is also of a serious nature. The scooter of the petitioner number one was stolen from his premises.
My lord.
From his place of work.
From his place of work. Full stop. The learned counsel for the petitioner for the petitioners has earnestly, EARNESTL, submitted that the petitioner number one is not at all willing to proceed with the case, and thus the possibility of conviction appears to be remote and bleak. To stop further proceeding will be an abuse of the process of the court. To stop. The petitioner number one had approached the police on several occasions to withdraw the case against the
Yes,
to
to
withdraw
close the case, but
against
the IO served a notice.
minor. But the police started to pressurize the petitioner number one to hand over the seized scooter of Activa make, no?
Yes, Lordship. These are lists there, page 18. Page 18, one white colored Activa 3G bearing registration number.
I'll stay the proceedings. I'll stay the proceedings.
Lordship, FIR, praying for quashing of the FIR.
I'll pass an order to take no steps. FIR, it's not required actually, Niharika Enterprise.
My lord.
So the case is still under investigation, full stop, call for the CD. Meanwhile, no coercive action to be taken against the petitioner number two.
Lordship, in fact, I am praying for the vehicle, Lordship, that vehicle to be returned to the petitioner.
No, cannot.
Jimma, I have, Lordship.
It will be given in
already
Jimma,
filed.
madam. In the Jimma.
Jimma already filed, but the police is not submitting
You
the
have to
report.
pray for a Jimma, you have to submit a Jimma petition.
Jimma already filed, Lordship. On last two occasions, police did not submit the report, Lordship. So finding no alternative, I have filed this quashing
No,
petition.
from this
so that-
petition, you cannot, first initially you'll have to file before the court
Lordship.
and then you'll have to file here.
My lord.
Lordship, and I, Lordship, want to produce the certified copy of the closure of this case to the Jimma court so that a order can be passed against the.
I have already given an order, no coercive action to be taken.
Lordship. Can it be recorded that there is no bar to give the Jimma of the vehicle?
No, my lord, it is not the forum, my lord. they will have to approach before the court below for Zimma of the vehicle. If it is rejected, then they can approach before this court,
Then
my lord.
Lordship may take it on next week, any date, Lordship, on that day, Lordship may dispose it up.
No. Cannot be disposed of through this petition. It will after all say no coercive action may be taken to capitation. It will liquid as it appears that an order can be passed. Not to take coercive action against the petition number 2. And thus it is directed that no coercive action to be taken against petitioner number 2. For the city.
No
No.
further investigation will be required,
No.
Lordship.
We are calling for the city.
City, my lord, stay is not
investigation.
possible, my lord. at this stage.
Obliged.
My lord, notice not required, notice and
Issue
call for
notice.
it.
No, only you are the.
I am,
respondent.
my lord.
I have already recorded that.
My lord, call for
And
city.
they are joint petitioners. The informant is the joint petitioner.
My lord, call for city only.
Lordship.
City.
My.
10th of January, Lordship. Obliged, Lordship.
Item 9. If you can take back your judgment.
May I please, Your Lord? Also, in a nutshell, I'll say, my lord. There was a complaint case filed by the respondent number 2 against me, my lord, under section 138 of the N Act, my lord. I appeared, my lord, and I was on bail, my lord. Subsequently, my lord, the complainant, my lord, filed an application for correction of the complaint, my lord. Some typographical mistake was there. my lord. Thereafter, my lord, that petition was allowed, my lord. Against that, I went to the Sessions Court, my lord. The Sessions Court otherwise upheld the trial court's order, my lord. Thereafter, neither my advocate informed me about that, my lord, and thereafter subsequently NBWA and eventually it was PNA, my lord. So I want to participate in the proceedings, my lord, and this is my humble prayer. Now I'll take your lordship to page 20 first, my lord. Page 20, my lord. So that I can show your lordship that there was no such intentionally or deliberate attempt on my part not to appear, my lord. Page 20, your lordship would find. Page 20, your lordship would find, upon perusal of the materials, it appears that there are sufficient grounds to proceed against the accused under 138, my lord. Now, lordship would find page 23, my lord. Then page 23, I appeared and I have taken bail, my lord. Page 23. This petitioner, my lord. Trial magistrate is on transferred, accused is present along with petitioner was so and so prayed to allow to him to go on bail, heard perusal, 10,000. Later on, bail bond was accepted, my lord. Now, my lord, find the very next page, page 24, my lord, annexure 3, my lord. Complainant is present, accused is absent with steps filed petition. Complainant side has filed a petition bearing number so and so seeking permission for correction of typographical mistake in the complaint petition, my lord. So thereafter, next page, your lordship would find we took time for filing a objection, written objection, page 25, my lord. Thereafter, my lord, this annexure 5, page 26. This order was, the correction application was allowed, my lord, by the order dated 19/7/18, my lord. Then, my lord, against that particular order, my lord, would find we filed a petition before the session judge. My lord would kindly come to page 32, annexure 8, page 32, annexure 8.
Okay.
Accused by petition number informs that he has filed a criminal revision petition before the court of the Honorable Session Judge number 3, Kamrup M. White so and so. In the said criminal petition, the further proceeding of the complaint has been stayed till disposal of the revision. So, my lord, my counsel said me, you don't need to appear before the trial court since this matter is pending before the session court. Only after the disposal of this, I'll communicate you and thereafter you need to appear. And in the revision application, your lordship knows that the appearance of the parties are not required, only the counsels are. So, my lord, thereafter this second order, page 33, the revision was dismissed, my lord.
Okay.
And my lord, on that day, neither parties appeared, neither the complainant nor the accused, my lord. Only the court received the record, so the order was taken. Annexure 9, page 33, my lord.
Okay.
Then, my lord, the next date, page 34, my lord. The trial magistrate is on leave, complainant absent with steps, accused is absent without any steps, issue NBW. So, my lord, thereafter, since I was not communicated, my lord, I could not appear. In the meantime, my lord, after 2 dates, my lord, COVID-19 was there, my lord. And thereafter, my lord, the proceeding went on. Now I'll show Lordship some part of the orders which says that the complainant has not even taken steps of PNA also. That is why, my lord, I was not even aware of the proceedings being there, my lord. And I tried to communicate, my lord, from reliable sources, I came to know that because in some other colony, my lord, in another apartment, my lord, they affixed a notice of proclamation, my lord. From there, one of my friend said that in that society, I've seen your name. But that is not because the complaint, I've placed the additional affidavit, my lord, the address of the apartment and my, I'm residing at Kumarpar, Rupnagar, and that was made in some other apartments, my lord. So my only opinion is that this order may be recalled or stayed, my lord, and I'll appear on 20th, my lord, the next date is fixed, my lord. I'll show, my lord, I'll show that part also, my lord. My lord, kindly see page 54 for a moment.
Amount? NIA amount?
Amount is 20 lakhs, my lord.
So you disappeared.
No, no. My lord, why I'm saying so is that, no, my lord, I have given the flats. I am a builder, my lord. The complainant is the person who was there for the flats, my lord.
You do not have any ground.
My lord, kindly see page 54. For a moment, kindly turn to page 54. But thereafter, I was not communicated, my lord.
No, I will not allow this.
My lord, otherwise,
No.
My lord, kindly see page
No,
54
I
for a
will not allow
moment.
this.
My lord, I'll just show the orders, my lord.
This is a complaint case.
Yes.
Your revision was taken up by you. I will not allow this.
No, my lord, the revision was for the correction order. Against the correction order, I went, my lord. My lord, I went only against the correction order, my lord.
Started shifting residence and then you.
No, my lord, no. My
This
lord,
is an NIA case, so this is not a criminal case also.
no, my lord, that is correct, my lord. But my lord, from serially, I'll show the orders, my lord. My lord,
And now you contest the case and then again you'll disappear. No.
my lord, my own.
You please appear before the learned trial court. The trial court will do whatever required.
My lord, this is what,
No,
my
I
lord.
cannot allow this.
My lord, this is what, my lord, my lord, after the dismissal of the revision, my lord, had the advocate could have taken a time for.
Adjournment, I'm not allowed. Others on the first day, I allow first time of petition. Smriti adjournment, I'm not allowed.
My lord, then I'll take an adjournment, my lord. I've tried my luck.
January. Or tomorrow if you, or next week if you.
Next week, my lord, next week is there now. Because, my lord, why I'm saying so is that, my lord, thereafter the orders did not show me.
Before me, I'm here next week.
Oh, no.
January will be safe. I'll be away for 1 week. From 5 to 9, I won't be here.
But, my lord, my honest intention is that on 2012, the matter is fixed. So, my lord, since I want to appear, my lord, that is why I filed the entire order sheet, my lord. That is why I filed.
Sorry.
But, my lord, next week or, my lord, on first week of January, any day, any day.
January 5 on 5th. Learned Counsel Mr. A. Tiwari has paid for adjournment. This is the matter on 5th.
I'm deeply obliged.
My pleasure. In this case, we have to challenge the rejection order, rejection of our prayer for defreezing the post office accounts and return of seized articles after conclusion of trial and acquittal of the petitioner. And those which are not exhibited in the case. Now, page 19, Lordship, kindly see. This part of the order.
You are against this order?
No.
You have come against this order?
No, I am against page 101, page 101. Our prayer for defreezing the post office accounts, joint post office of the petitioner and his wife, and return of seized articles, which are not relied upon in the case and which are not proved in the case. That was rejected only on the ground that the CBI has filed a appeal.
What is the account?
What's it? Ground.
What
Ground.
is the account? Wife of the accused.
A joint account. Joint account. Wife of the petitioner.
And this is the amount their CBI is against.
No. This is the ground. First, this has no connection with the case. It was a trap case for something, and he has been acquitted. And they have proved certain documents. These are not relied upon also. And this freezing of the account also not communicated to the court. And when we filed the applications, they did not deny also that we have not freezed it. And post office has informed that this is freezed by the CBI. They have submitted reply to our application also. There is nothing. And seized articles which have not been exhibited. Now there is order of the court also to return the seized article. When we filed this application after 6 months of the acquittal. This has been rejected on the ground that it's-
Yes, we need to file reply. I have to take the instruction because we have already preferred an appeal before this honorable court and the matter is pending.
appeal has not
Not
been
yet
registered yet.
No, it is
Appeal has not been
registered.
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 Huh?
I have the knowledge. It is registered.
No, it has not been registered because
there-
they
there
did not
was a
file any
delay.
writ petition.
There was a delay of 4 or 5 days only. So the matter
There is a
has.
filing number is there, but nothing.
No, it has come on board. Notice has been issued.
Letter file objection.
Otherwise,
Notice is
exhibited,
not required to be issued, no?
not
we
required.
don't
It may come up in for admission lordship. By this time, they can file the report.
We will file the reply paravise reply.
Learned
During which time may
counsel-
kindly be granted, Your Lords.
Okay, learned counsel Mr. S.B. Prakash is present for the petitioner. And learned standing counsel CBI Miss Emma is present for the respondent and has accepted notice. Full stop. It is submitted by the learned counsel for the standing counsel for the learned standing counsel that time may be allowed to file objection. List the matter on DPD on
9th January. Either after Bihu or before that. 9th mana thaking. 9th January. Much of that.
So it may come up for admission lordship. Otherwise, it will come in orders and it will unnecessarily.
Let it be to file objection.
Oh, by this time, she file. Because it will come on 9th or
Let me
7th.
file, let it come on now. Much of that.
May I please, your lordship? Lordship, the accused petitioner, before your lordship, he was arrested in the ZR case bearing number 708 of 2020, Dhemaji district. And FIR is at page lordship 19. That is type copy. But the case was actually registered, initially registered under sections 448, 354, 325, 307, and 34 IPC. But later on, when police filed the Samsit lordship, so the sections attributed were 341, 354, and 323 of IPC.
Okay.
Lordship. And lordship may kindly come to page 6, para 8 of my petition, lordship. The petitioner before your lordship is a temporary employee of a medicine company located at Goa, lordship. And he has 4 dependents. His ailing mother, his sister,
No,
who is,
these are not grounds for quashing.
no, this is not question, lordship. No, I'm for setting aside the orders. NBWA, setting aside the NBWA.
NBWA.
Lordship,
Okay.
okay. And thing is that, lordship, so he was working under a
Have you
contract.
given all their orders? Copies of the orders?
Yes, yes, I have a next.
Which page?
From page 30, lordship. Lordship may kindly come to page 30. Peruse the case record and case diary. The IO has submitted the case in charge sheet under section 341, 354, 323 IPC against accused Prosen Bonia. On perusal of the case record and case diary, I have found sufficient ground to proceed against accused Prosen Bonia under section so and so, and accordingly cognizance is hereby taken. Issue summons to the accused persons. So 21/5/2021 for appearance. Then next page, lordship, page 31. Accused Prosen Bonia is present. Seal petition number so and so filed by accused. So his bail bond is accepted, lordship. 15,000 bail bond, and that was accepted. Then next page 32, lordship. Issue summons to witnesses, prosecution to take steps. Then 33, lordship. Accused is absent, which
He appear. All right. He
lordship.
can appear, I think.
One thing is that, madam, After PNA.
Lordship, I'm coming.
No, let him complete.
Sorry, it's okay. It's not required to be submitted. He wants to appear, let him appear.
Lordship.
We can defer the PNA.
PNA is
PNA not executed, not communicated. No process. Oh, he does not have any movable and immovable property. So
Page
could not be
41.
executed. So Lordship, I will appear and I will face trial, Lordship. And he has 4 dependents. His ailing mother, his sister is mentally retarded. 100% mentally
Our
retarded.
learned counsel, Mr. Unique,
TK Mishra.
TK Mr. for the
Lordship, Prasen Bonia, please petition.
petitioner,
Lordship.
Prasen Bonia, who has filed his application number 528 of the BNWS 2023 with prayer to, what is the prayer?
My prayer is to set aside the NBWA and PNA and all subsequent orders after that.
To set aside the orders in GR case number 708 of 2020, issuing NBWA and PNA against the petitioner.
Lordship, the impugned order dated 7/12/22 and all other subsequent orders.
Had Mr. B. Sharma, learned additional PP Assam. Full stop. The learned additional PP has accepted notice on behalf of the petitioner.
Respond number 1.
And has raised serious objection against the prayer to set aside the PNA and NBWA. Full stop. It is submitted on behalf of the petitioner that it has been submitted against him under section 354. What are the sections?
341, 354 and 323.
341, 354 and 323
Lots.
RPC. It is submitted that the petitioner was working in Goa, full stop. He was appearing, he was absent with steps on several dates, but NBWA was issued against him when witnesses were present. Full stop. On that day also, that is on, which was the first day?
7/12/22, Lordship.
7/12.
NBWA edition.
The petitioner, 7/12/22 steps have been taken for the petitioner, but as the witnesses were present, the petition was rejected. The petition with prayer for adjournment was rejected.
Yes.
And then warrant was issued against the petitioner.
And PNA also.
Finally, due to non-appearance of the petitioner, PNA was issued against him. Full stop. The petitioner is now willing to cooperate with the trial. Full stop. The petitioner is the sole breadwinner of his family and he has to take care of 4 family members. Full stop. Most of the time the petitioner was in Goa.
Lordship.
And thus he was unable to appear when the witnesses were present. Full stop. There was no matter fide on the part of the petitioner or the petitioner did not, nor did the petitioner try to evade appearance in this case as steps were taken against him. Full stop. I have considered the submissions steps were taken against him initially. Full stop. I have considered the submissions again at the bar with circumspection. It appears that instead of protracting the case, the petitioner's appearance will result in the culmination of the trial. Full stop. I have also considered the submission that the petitioner is willing to cooperate with the trial. Full stop. I have taken a pragmatic view, thereby the NBWA and PNA already issued against the petitioner is kept in abeyance for 15 days. And within these 15 days, the petitioner is directed to appear before the trial court and cooperate with the trial.
Deeply obliged.
In terms of the above observation, this petition is this petition stands disposed of.
Item 12.
May I please, Your Lordship? Lordship, petitioner before you registered local owner of a truck which was seized in connection with an FIR registered under the NDPS
You
Act.
want a truck?
Yes.
We'll need a report Investigation stage or trial stage? Cases pending will be
It's
stage.
investigation,
Investigation.
charge sheet not filed.
Okay.
My lord,
For
report,
a report relating to the truck seized in
My
connection with
lord.
this case.
my lord.
List the matter on date.
My lord, this mail petition for quashing of the ERC case number, Lordship 319/2025, arising out of Gogamuk PS case number 11/2025, under section 318, subsection 4 and 336, subsection 3, that is cheating and forgery. Earlier, it was, my lord, 420 and 460. And so far, my lord, FIR and enter case is concerned, well, cheating and forgery is not acted. Because I have not involved in a personal benefit. No, I am not beneficiary in this case. I was the president of the construction committee, and construction committee constructed the construction. And there is a period is bill already granted, my lord. It is appear on the period of cheating. That is page, my lord, 21. Period bill was granted by the board in bench of this one court. Page 21, para 8. Clearly mentioned that whatever amount released, that has been utilized. Para 8, my lord, kindly page 23, that on perusal of the record, it appears that the amount of rupees 5,48,184 out of total amount of rupees 7 lakh for this scheme has been utilized for the construction of Southern Forest Mission. So release amount 5,48,184 and estimate amount was 7 lakh. 7 lakh was not released, but FIR saying that entire amount I have
been submitted in this case.
lordship. Therefore, trial is going on, my lord.
Yes.
And
My lord, here it is the charge sheeted case, my lord.
Mm.
After getting the materials, my lord, during the investigation, charge sheet submitted, my lord. Lordship may call for the trial court record at this stage, my lord. After receiving the LCR trial court record, Lordship may consider that, my lord.
We will consider.
My lord, not at this stage, my lord.
Kindly have a look, my lord. FSL report also saying there is no any finding against.
Lordship, page 36, my lord. I
FSL
point out, my lord.
let-
Page 36, my lord. Charge sheet, my
FSL
lord.
report, my lord, page, my lord, 26.
Page 36, my lord, charge sheet, my lord.
Yes, sir.
Against the Guneshwar Farley, my lord.
Because this overlook this FSL report.
My,
Therefore, I am appealing to this one.
ওপৰত নাম উল্লেখ কৰা গুণেশ্বৰ ভৰালী ভুক্তভোগী ডাইৰেক্টৰ
How can areas?
স্পেচিমেন চিগনেচাৰ হেণ্ড ৰাইটিং গুণেশ্বৰ ভৰালী ষ্টেট বেংকত জমা দিয়া টকাৰ চেক নম্বৰ তেখেতে লিখা নাই বুলি ব্যক্ত কৰে FSL report is clear, my lord, that the check was signed by any other person. That is the Guneshwar Farley, my lord. Is the petition.
FSL report, lordship, page 26. Page 26 opinion, kindly have a look, lordship, for a moment. That has overcome.
No, my lord.
That has not taken place in the charge sheet. Therefore, I am appealing before the lordship. Because FSL report says that the case may be resubmitted due to inadequate amount of standard writing. It is not been possible to express a definite opinion. So FSL report doesn't say regarding the forgery, they failed, saying that express a definite opinion regarding the authenticity of the red and close writing mark Q1 to Q4. And the case may be resubmitted, but that has not been complied. The case may be resubmitted if sufficient amount of specification writing is at least 5 pages with some contents as the question writing as well as some admittedly genuine writing of the concerned person are sent. But that has not been complied. How the court can ascertain the genuineness? Because FSL would fail, and that has not been complied. FSL, the forensic laboratory, the scientific officer.
We can call for the scan copies of the trial court record, and when the record comes, yes.
It may be given, but because it still may be given. I am not involved in this case because the FSL report says.
No, my lord.
And
Here-
lordship, very important, page 16, the former video already given this letter. Now this video disturbing me. Page 16, my lord. Page 16, former video who was during the situation was in charge of the block. He stated that properly utilized
the release amount. So this is the release regarding release amount, release fund of the construction of Sadhani College of Education Institution at Balisar Pori, Gogamo, under Sutia Development Council for the year 2022-23. He stated former video that whatever amount released, that has been properly utilized. Now the present video disturbing me, unnecessary. And FSL report was saying, if sufficient specimen appear, then resubmit. That has not been complied by the IO. Now court how can assert it regarding the forgery?
Well, again, page
And so
35,
far, and so far 420 is
Where is
concerned
the
earlier. Lordship,
Where is the FSL report page?
FSL report, Lordship, page 26. Page 26, Lordship, paragraph 3. Due to inadequate amount of standard writings, it has not been possible to express a definite opinion regarding the authorship of the red enclosed writing marked Q1 to Q4. The case may be resubmitted if sufficient amount of specimen writing, at least 5 pages, with some contents, the same contents as the question writings, as well as some admittedly genuine writing of the concerned person are sent for comparison along with the question documents. That has not been complied. No resubmission, and directly submitted charge sheet. And how the court below can ascertain whether the genuine or not? Whereas the earlier video already given this letter regarding utilization of fund.
My lordship.
So this is the case, my lord.
This is allegation of forgery.
My lord, forgery, lordship may kindly page 26.
No,
One, my lord.
when
One, my lord.
lordship, forgery when there is a personal gain, because there is a construction committee. I was president only. I was not sole person to construct. So
We will
beneficiary,
Call for the records.
My
We will
lord.
call for the
no,
records.
call for a record right now.
We will
but the
consider
stay
your-
is to be given, my lord.
My
No, we will consider your stay after the records received,
Right.
after we receive the record.
The record, everything, certificate we have submitted, and this FSL
No, I
report
want the
also
statement.
certified copy, my lord. Everything is all
No,
certified
no.
copy.
I want the statements under
My-
section.
Same thing will appear,
161.
my lord, and on the basis of
No,
charge
no,
sheet.
same thing won't appear. Under
And
section
lordship, on
161.
the basis of CD, the court, this honorable court already note.
This is bail. This
Bail,
not
it is
because
a
bail.
quashing.
on the basis of CD. On the basis of CD it shall reflect that 5,48,148
But it was at
utilized.
the stage of investigation. Now charge sheet has been submitted. There are more materials.
Mm.
Otherwise, they
And,
would
and,
not
tar-
submit
and
charge
charge
sheet.
sheet, this is bypass, FSL report.
If you saw
FSL
it
report
was
bypass.
charge sheet submitted again.
Charge sheet, I have submitted an entire charge sheet, and charge sheet also saying that it has not been resubmitted. This is.
My lord, my submission is only.
Read each and every detail of the.
Lordship,
document.
kindly page 26, para 1. He is not reading the page 1, para 1, my lord. He is reading of para 2, my
Which
lord.
one?
Here, 1 it is,
I have read it. There is
my lord,
nothing
para
saying
2,
that
my lord. It is
for
clear,
records.
my lord. It is clear, my lord.
We'll call for
Kutu
the
poro,
records and
kutu no
we'll
pore
con-
diyo.
we'll consider
Edu,
it.
26 or para 2. It was decided a person who wrote the blue enclosed writing and signature stamped and marked as S1 to S6
No,
did not write.
Description of
That
the
is-
exhibit.
He want to
This
that
is the
is clear.
description of the finding, you see finding. This is the description of the exhibit.
This is the finding.
That is.
Finding,
2,
see.
para 2,
Then
There
that
are
is
two.
supporting
Ah.
the allegation.
para 2.
Just a moment. I'll call for the
My lord.
records. We'll consider your prayer for interim.
Still may be given.
We'll consider after the records.
My
are
lord.
received. Third learner counsel, Mr. K. Bhuya, for the petitioner. And learner additional PT, Mr. B. Sharma, for the respondent state.
Notice also required, my lord, for respond number 2
Petitioner to take steps to issue notice to respondent number 2
and 3.
and 3
Well, see.
returnable on January the year. Meanwhile, call for the scanned copies of the
PRC number,
huh?
PRC number 319,
Record of PRC number 319
2025,
or stroke 2025,
pending before learned CGM,
pending in
Dhemaji.
the court of the learned CGM, Dhemaji.
Yes.
List, it would be as
And interim,
Along with the scanned copies of the
and,
CD.
and regarding,
Prayer for interim, the prayer of interim may be considered on receipt of the scanned copies of the records.
That's
yeah, please. 482 application, Your Worship. The respondent had filed a complaint with case. Cognizance was taken under 498 and 406, you know. It's pending before the trial court.
498A 406.
406. yeah.
Husband, wife,
Otherwise-
joint petition, no?
No.
You have objection?
Yes, I have been appointed as an amicus to represent the respondent number.
Do you want the records?
Worship, in this case, Mr. Ahmed Sarul appear, he seeks some more time. Worship, matter may become upon after vacation.
After vacation?
My lord, my lord, before you lordship.
You have not received
Submission, my
the
lord.
amount?
No, my lord. That's why, my lord, I am submitting, my lord. My lord, maintenance order was passed by the learned court below, my lord. From the date of 7, he should be paid, my lord, 7/11/2022, my lord.
Where is your sin?
He's in the lordship. In this regard, we tried to communicate with the petitioner, my lord. We cannot communicate. So in the meantime, we shall try to communicate with the petitioner. After vacation, we.
Okay. Why she is not responding to the communication?
My lord, first week of January, my lord.
Okay. Learned Counsel, Mr.
And Jaman,
N. Zaman, on behalf of Learned Counsel, Mr.
J. Ahmed.
J. Ahmed has prayed for adjournment. Learned Counsel, Mr.
A manna.
A. Manna has raised objections stating that the petitioner has not paid the maintenance amount and the respondent is suffering immensely, full stop. The Learned Counsel appearing for the petitioner submitted that they tried to communicate the respondent, but they were not met. But the respondent has not responded to the communications. Respondent has not responded to the
This
communication.
petitioner.
I know. I'm saying the respondent has not responded.
No, petitioner is not responded. We try to
No,
communicate.
no. Here the
I'm my lord, a wife respondent.
is the respondent here.
He is the petitioner.
In the original case, she is the petitioner.
My lord.
Yes.
Respondent wife has not responded. Now the misunderstanding has occurred.
Obliged, my lord.
I trial court record call করার কথা আছে নাকি? খরচ করতে ভালো হবে নাকি? Dispose of our case. Call for the original records of the trial court.
IA is filed for interim order, my lord.
Item 15 records.
Oh, IA for bail.
Yes, ma'am.
Case is under which section?
324, ma'am. 323, my lord. Charge sheet has been submitted under section 323 and 307, the IPC. But charge frame under section
Convicted here close to conviction here.
conviction, my lord, 323.
How many years? 4 years?
1 year, my lord.
1 year. And what is your prayer in the IA?
IA, my lord, charge sheet submitted under section 223.
No.
I for bail, my lord.
So may I kindly see in the appeal memo, my lord, page 37, ma'am. Last page. He is allowed to remain on previous bail till 15/12.
We'll extend the previous bail.
Yes.
Or we'll give fresh bail. Fresh bail.
Fresh bail will also be
Next
given.
day.
Can also be given.
But you haven't made a prayer for bail here.
Yes, my lord. Till disposal of this appeal, my lord.
Where is your prayer? For bail? Or suspension of sentence?
Prayer is page 7, my lord. In the IA, my lord.
Yeah. There's no prayer for bail.
Yes, sir.
Should be suspended during pendency of the present appeal. I
What
may
to
be,
do?
I may be allowed to correct you.
Yeah, there is no, there, that is the fact. But
When will you correct? Monday? You can file one more application.
Additional evidence.
Affidavit, no, again, again,
I
affidavit in
better
IA.
withdraw this IA and file a fresh.
15 is fixed date, my lord.
You ask for extension there then. What to do? Advice, good advice, good piece of
Otherwise,
advice.
Lordship, if I may be allowed to correct, I will correct.
otherwise, suspension is,
Good day,
my lord, suspended can be there, my lord.
We can pass an order for suspension.
Suspension, my lord.
And
Previous
extend the previous bail. Huh?
Till-
We'll extend the previous
my-
bail.
till 15
And then you, meanwhile, you file an application for bail.
Application.
Huh?
15th, yes, 15th is a Monday, my lord.
This is appeal, no?
Yes, ma'am.
This is appeal, my lord.
We'll extend till the next week,
Yes,
entire week, and then he can file the application.
yes.
My lord.
Learned Counsel, Mr.
K Islam.
A.
K Islam.
K. Islam is present for the petitioner, Jahanuddin Sheikh, who has filed this application under section, application. You have not given the section also in the prayer portion for suspension of sentence.
Had the section is there, then also your lordship would have been.
Yes,
If the section is there, then also lordship would have been, my lord, exercise the jurisdiction, my lord.
on Monday, you take adjournment till Monday. Huh? You have not added the section also, under which section to be suspended.
Better to withdraw this, my lord, the interlocutory application and file a fresh.
My lord, I will file a fresh, my lord.
Okay.
In the meantime, suspend till next date, my lord. 15 is fixed, my lord.
Section has also not been mentioned.
Yeah, in the main, my lord, 415 an appeal, that is there, and here nothing is there.
Check the rules. Check the rules.
No, just
Can I, without,
my lord, in my lord, IA, my lord, he has quoted the section 430, my lord, for suspension, my lord.
he has quoted the section.
Yes, my lord, in my lord, IA, my lord.
No, that is for appeal, I think.
No, my lord, pending suspension of sentence, pending appeal, release of appellant on bail, 430.
430, no?
Lordship,
Let
may
me
kindly,
check.
lordship, may kindly check.
Okay, yes.
Lordship.
I think we can release him on bail,
Let's-
although no prayer has been made.
Lordship. Section 40.
Mhm. Under section 430,
Under
I think
section
we can release him on
No.
bail. Our learned counsel नाम तो लिखला नहीं for the petitioner to case का नाम तो लिखला नहीं petitioner applicant petitioner no है applicant stroke appellant petitioner no है के भाई no Jahanuddin Sheikh, who has filed this application under section 430 of the BNWS 2022 with prayer for suspension of the with prayer for suspension of the order of conviction and sentence dated 15/11/2025 passed in sessions case number capital T2 stroke 23 stroke 2023 comma GR case number 800 stroke 2022 under section sentencing him to undergo SI for 1 year and to pay a fine of rupees 1,000 under section by convicting him under section 324 by convicting him under section 324 IPC. Heard Mr. MP Goswami learned
Paragraph 15, my lord, of the paragraph 15 of the IA, my lord. Last part, my lord, he has made it clear.
Okay.
Last part.
I have considered the submissions that the applicant is the sole breadwinner of his family. To stop. I have also I don't know, like, it is submitted now. I have also considered now, like, it is submitted because it is submitted that there is every possibility that the appeal will succeed, considering all aspects, the operation of their order of conviction and sentence of the judgment and order dated 15/11/2025 in connection with sessions case number T2/23/2023 is hereby suspended until further orders, and the petitioner applicant is allowed to applicant is enlarged on bail of rupees 10,000 with a suitable surety of like amount to the satisfaction of the learned. There will be trial court, no?
Yes, ma'am.
Learned trial court, who may also impose conditions if the court deems fit and appropriate. Yes. It will be appeal of litigant. The appellant Jahangir Sheikh is present, MP has preferred an appeal against the order of conviction and sentence dated 15/11/2025 in connection with sessions case number T2/2023/2023, whereby he has been convicted under section 24 of the IPC to undergo simple imprisonment for 1 year and to pay a fine of rupees. How many it is this? How much amount money?
10,000.
10,000. 1,000.
Oh, sorry.
1,000. Pay a fine of rupees 1,000
Annual for it,
for
yes.
stipulation. To stop, admit. The learner addition PP has accepted notice on behalf of the respondent state, and thus no common notice is required to be issued. Extra copies to be furnished. Call for the trial court records. Any respondent, other respondent? No.
No, ma'am.
No.
List on 21st January.
My lord. I am obliged, my lord.
I dispose.
Item 16.
This is an application under section 482 of the Code of Criminal Procedure. Read with section 528 of the NSA, praying for quashing of complaint petition 510C/23 pending in the court of SDJM 2, Kamrup Metro Constitution. My lord, what happened in this case, my lord? The respondent number 2 has filed a complaint before the Honorable Court of Chief Judicial Magistrate, Kamrup Metro at Guwahati. Alleging inter alia, my lord, at the operative portion is at, my lord, 70, page 70.
You are prepared, no? I'll tell you just one minute. I want to inform you, we do not have the records. If you are prepared, it's okay.
Yes,
We don't have the records.
My lord, I am prepared.
But
My lord, we have applied the certified copy. and
will
we
you
have-
need the records?
Yes, I
Not
have.
necessary, absolutely, but
The record.
already I have this is the basis of the complaint petition only. Because in this regard, my lord, there is another two FIR has already been lodged before the dispute police session.
I won't need the records.